Our final keynote speaker is Paul Diamond. Paul has had many victories in the courts in seeking to uphold religious freedom in England. It doesn't have to be just Christian groups. A lot of people who are Catholics now have a pair of rosary beads in their car hanging off their windscreen, their rear vision mirrors. Probably a dangerous thing to do from your safety point of view, but just imagine if you're likely to get arrested for doing that because you are exploiting some religious belief and trying to brainwash others. And I don't think that's a far-fetched thought at all when you consider that we're supposed to put up with some of these signs that they put up near schools and that advertising certain herbal treatments which exploit your masculinity. We had one at the West Epping Public School recently on the bridge going across to the school where all the children are supposed to walk on. They had an enormous sign in yellow and black with an ad for this particular famous company. It was put up about 4 days before school was due to resume. Luckily, because there was a fair bit of outcry, the Roads and Traffic Authority removed it within 2 days, and they put up an ad there for a TV set or something like that. But that's just what's happening in our society, and one of these days those things may be seen as the norm, and our views, particularly if we put up some sign urging people to bring Christ back into Christmas or something like that, we may be the ones in trouble. So with those words, I introduce to you the niche barrister from London, Mr. Paul Diamond. Thank you.
Thank you very much. First, I'd like to just give my thank yous. I want to thank Rocky Mimo from the Ambrose Centre for Religious Liberty for inviting me in this invitation to Australia and your beautiful country. I ought to say I have to also apologise that to some extent I'm going to repeat what I said at the Law Society. I also have to say I'm now really furious with my co-speakers as they've taken the steam out of all my points and said it more eloquently than I could have possibly said. But I can at least speak from a practitioner's point of view and from experience on this area. I think the thing that comes away from, just by way of introduction in the United Kingdom, is that we didn't see the gathering storm, and we were 4 or 5 years into the situation, which I will illuminate in a minute, before we realised that we had a very serious problem on our hands. And by that stage, there were a number of judgments against the interests of religious folk. And the Australian people need to gear up now. They need to get organisations like the Ambrose Centre for Religious Liberty up and running now and not wait, as we did, until it was too late. I feel like saying I've seen the future and it does not work. I remember our Human Rights Act when it was passed in 1998, and I remember that because I was actually instructed by some peers to draft the religious church exemptions to be put before Parliament, and we did have religious exemptions, which I'll come to in a minute. They lasted as long as a judge would say they have no bearing at all, but we did attempt to do that. And it was a very, very similar process, I suspect, to what's taking place now in Australia. Human rights good, no human rights bad. Put your hand up if you're in favour of torture. It's a positive move. It will create a human rights culture. Who could be against that? We'll entrench the rights against a totalitarian state which is barking at our feet. We were out of step. That's what they said about the United Kingdom. Australia had a constitution. It was played hard. We had no Bill of Rights and no constitution, and it needed to go forward. It also had a very strong attraction, I have to say, to the parliamentarians in our country, because, of course, it was received in this positive spirit in which a lot of the problems were glossed over. And the parliamentarians rather liked it because it was a cost-free measure. It made a very principled stand, and the burden of expense was borne by private litigants in the courts. It has had, I'm afraid, a very serious and detrimental effect on British society. And I'm sure we can all remember Britain in 1998. We had no bread in the shops. We were shuffling around. We had no freedoms, no freedom of speech, and no freedom of religion. And without the Human Rights Act, we'd be in an appalling state. And in fact, it is no mean statement to say that actually we have less freedoms now, considerably less freedoms now than we did in 1998. In particular, we have the use of anti-discrimination laws against religion, which have been identified, ever-widening classes of discriminated groups, ever-widening bands of interpretation, and we've reached the ultimate irony of anti-discrimination laws used to discriminate. Hate speech as well prevents our freedom of speech. There's ever-widening categories of offensive speech. Essentially, the message is disapproved of, and it doesn't respect our traditional viewpoints of freedom of speech, the right of a minority viewpoint to be the majority viewpoint, the right to offend. I'm not talking about cheap offence, but the right to offend is greater than the right not to be offended. And of course, the ultimate principle of the philosopher John Stuart Mill's, that even if everybody in the world believes X and you are the only person that believes Y may be correct. And the process of arguing that distinction will reinforce or weaken X. And as a very famous American Supreme Court justice said, every idea is an incitement. So we've now reached the stage where the British people want the Human Rights Act repealed. And of course, the leader of the opposition, who's a very ambitious individual called David Cameron, who would like to occupy a residency known as 10 Downing Street within the next year, and he will not be saying anything that is controversial or likely to lose him votes, has said he will repeal the Human Rights Act. That's going to be a heave of a mess because of the judgments we have and established principles, but it is deeply unpopular. Why is it unpopular? Well, it's very I ought to say it's done me a lot of good. I've become the niche of the niche barrister, specialising in the law of religious liberty. But my cases are real. They're not fantasy. They're very, very real. And they are regularly front page of British presses, not because they like me, it's because they represent very serious fractional and structural issues in British society. And I had a look at the UK section of the Brennan report, and surprisingly, none of my cases were on it, which, considering I do most of them, you would have thought if he'd done a thorough job, he would cover that area. What have I had? Well, I just mentioned some of my more notorious cases, and perhaps if you wanted to sort of frighten yourself fully, you could have a look at my website, and I have downloaded some cases on that. But I did a very well-known case a few years ago about a lady who was employed by British Airways. And this lady at British Airways was not allowed to wear a cross. Now, the case was interesting because British Airways permitted the Islamic headscarf, the Sikh turban, the Sikh kirpan knife, including wearing it airside, the Sikh Hindu ponytail, all could be worn with the British Airways uniform. The only thing they fought tooth and nail to prevent, using human rights law, was the wearing of a cross the size of a sixpence, worn in conformity with our cultural traditions. Now, you can go into that, you can ask what's the legal arguments on that. I don't know how many lawyers are here, I'll be glad to take them up on questions, but I think you can see how insane it is. You don't have to have a PhD in law to know there's something seriously wrong. I have many cross cases in the United Kingdom. I had a case earlier this year about a nurse who had the effrontery to offer a patient, a lady called Caroline Petrie, whether she ought